Hello, our names are Zahava Molina
Haley Purich,
and
Jessica Vickers.
We are law students at Drexel Thomas R. Klein School of Law and are part of the Housing Stability Team at the Stern Community Lawyering Clinic for 2025. Welcome to our presentation on how to keep the government's hands off your home. This presentation will explain why it's important to create an estate plan to protect your home from government seizure and will guide in the process.
Disclaimer: this presentation is for the purpose of providing legal education, not legal advice. While we will outline some general information about Pennsylvania law, this information may not apply to other states. You should consult with an attorney who can make recommendations based on your individual situation. In this presentation, we will talk about some of the most common ways that the government can take your home and how you can stop that from happening. We will clarify some common misinformation and talk about some extra documents and tasks that you should include in your estate plan. By the time you leave this session, we hope that you'll feel ready and confident to take on the next steps in your estate planning journey. One of the main ways that the government can take your home is when the title gets tangled. Tangled title is a term used by lawyers and housing experts to describe a situation where a person lives in a home, but their name is not on the deed. Often this happens when homeowners pass away without a will and the property doesn't automatically transfer ownership to the person who already lives there. Tangled titles can make it difficult or even impossible to sell or refinance a home, or to get help with repairs or property taxes. Without this support, homes can fall into disrepair, which often leads to the home being condemned or abandoned, ultimately leading to foreclosure or sheriff's sale. Once the title is tangled, there is a risk that if the family can't agree on who should own the home, the court will eventually force a sale of the property and divide the proceeds among the family members. Tangled titles are one of the leading causes of a loss of generational wealth in Philadelphia. Here we have a chart that demonstrates how quickly a complicated tangled title can form. You are our client. Your grandfather's name is on the deed to the home that you were raised in and currently live in as an adult. You have come to us with the hope of getting your name on the deed, but sadly, we may tell you that this may not be as easy as you had initially thought. To understand this chart, you need to know that there's a law in Pennsylvania, like there is in every other state, that determines who inherits your property when you die without a will, called intestate succession. I'm about to tell you how the ownership rights to this property get split up between the grandfather's heirs under the law. We start with your grandfather. He passed away without a will, and the house was his only major asset, which is a pretty common situation in Philly. The ownership rights to your home are split evenly between all four of your grandfather's children: your mother, your two uncles, and your aunt, each with 25% ownership of the property. Both your mother and your aunt have passed away without making a will. Your aunt had two children, so her 25% is split evenly between them. Now each of those children have a claim to 12.5% of your home. Your mother's 25% of the house is now evenly split between you, your two sisters, and your brother. Each of you now owns 6.25% of your house. Regrettably, your brother has also passed away without a will. His 6.25% ownership of your home is split between his 5 children. Now they each have a 1.25% claim to ownership. You can see how many people can end up having a claim to part ownership of your home after only 3 generations, and the longer that you wait to remedy the situation, the more complicated it can become.
tangled titles are a massive problem in Philadelphia. A 2021 assessment by Pew estimated at least 10,407 tangled titles, which is 2% of all residential property in the city. Other experts agree that it's probably undercounting by a lot. Most of these tangled titles are in northwest and southwest Philadelphia, disproportionately affecting Black and low-income neighborhoods. Collectively, over $1.1 billion worth of family wealth is wrapped up in these tangled titles, and if they can't get them untangled, they lose all of that wealth. It costs an average of more than $9,000 in legal fees and other costs to untangle one's home title. There are nowhere near enough pro bono attorneys to help the folks that can't afford that. So we're going to tell you about the easiest way to prevent your title from getting tangled in the first place, by making a will. A will is the document that prevents tangled titles. It does so by clearly stating who should become the new owner of your house. This makes it much easier to either keep the house intact and in the family with one clear owner, or for your heirs to sell the house and share the wealth that you worked hard to put into that property. A will is a legal document that allows you to decide who gets your property, often legally called your estate, when you die. This includes your home, money, and other belongings. As we showed you earlier, if you die without a will, the law of intestate succession will decide who gets your property instead. That law essentially splits your estate evenly between each member of a generation of your descendants. It also guarantees a portion of your estate to your spouse if you're legally married. But most family dynamics aren't as simple as the law assumes. So the law of intestate succession might leave out people who are close to you, like a long-term partner who you're not legally married to, or a niece who is like a daughter to you. Or it might include people that you don't intend to include, like an estranged but legal spouse, or some but not all of your grandchildren. While we think that everyone should have a will, wills are particularly important to have if you are a parent, especially if you have minor children, if you are a homeowner, or if you have other valuable assets.
Probate is the legal process of opening an estate to settle the debts and distribute the property of deceased persons. The process often includes officially transferring title of the deceased person's home. In general, in Pennsylvania, any property that was solely owned by the deceased person and does not have a named beneficiary will have to go through probate. For example, if you have a life insurance policy where you named your sister as a beneficiary, that will get paid to her without going through probate. But if you have a life insurance policy and did not add any beneficiaries named, this payout from the insurance might become part of your estate and have to go through probate before anyone gets the money. You may have noticed that I didn't mention wills in the description of probate. That's because the presence or absence of a will does not determine whether or not an estate must be probated. It is whether the deceased person was the sole owner of any assets that needed to be transferred to someone else. I would like to know that this is the general rule, but there may be some exceptions. And you can see from this chart that the steps are actually very simple with or without a will. As you can see on the side with the will, if you have a will, the person you chose as your executor can take your will to City Hall to the Register of Wills where they can register the will and file a petition. The court will review this petition to recognize the will and the executor and give the executor permission to distribute your assets according to your wishes. On the other side, you can see if you pass away without a will, someone must still go to City Hall and file a petition to be an administrator through what is referred to as an intestate succession process. Typically, sole beneficiaries may be appointed as the administrator. And if there are multiple beneficiaries, they have to come to an agreement about who the administrator or co-administrators will be. If no agreement is made, an heir or multiple heirs may file a petition for a hearing. The administrator is decided by the Register of Wills and may be an independent administrator if it is deemed necessary. The administrator chosen by the court may not be the person you may have wanted to handle your affairs, but without a will, sadly, you don't get to decide. This person who's decided as the administrator will then split your estates according to Pennsylvania state law. Although the basic steps are similar, having a will can make a big difference in the probate process. With the will, the Register of Wills or the court has a much clearer guidance in naming an executor and distributing assets. And that often makes the process shorter and easier to navigate because there are fewer open questions. You may have heard nightmare stories about families getting stuck in probate for years, and that definitely does happen. But those stories might involve family disputes, people who may have potential heirs dying without a will, people dealing with tangled title, or they may have happened in other states where the probate process may be more complicated and expensive. Fortunately, the probate process is generally simpler here in Pennsylvania than it is in many other states, and a lot of people actually go through it relatively easily. In Pennsylvania, if you have a will, there's a very good chance that your family will be able to go through probate without even trying to go to court. You may have heard that some people are looking for strategies to set up their property to avoid probate, which is sometimes because they want their heirs to avoid paying inheritance tax. Unfortunately, that's generally not really possible in Pennsylvania. We have already covered how probate may be required whether or not there is a will, depending on the legal ownership of the property. Similarly, inheritance tax in Pennsylvania is not based on how the property gets distributed, but just on the relationship between the deceased person and the heir. In Pennsylvania, the inheritance rates are as follows. Charities and spouses will pay 0%, children and grandchildren will pay 4.5%, your siblings will pay 12%, and anyone else you leave anything to will pay 15%. You might also be thinking, why not put my house in a trust so that when I die, the beneficiary of the trust will just become the owner without going through probate or paying inheritance taxes? You may have seen people talking on social media about this too. We definitely have. There are a lot of different kinds of trusts. So what I explained here is only going to apply to a particular situation of using a trust instead of a will to pass the ownership of a house to another person. This is referred to as a living revocable trust. Generally, a trust is a legal entity that is created to hold and manage property. All trusts will have a trustee, who is the person who does the managing, and also a beneficiary, who is the person who benefits from the trust, and this usually includes yourself. Your home will legally be owned by the trust. So why isn't this better than making a will and leaving your house to your heir? It's not really worse, but at the end of the day, there's no real benefit for most people. And it's more expensive to create a living trust document and retitle your assets. Paying a lawyer to make a simple will for you or getting a pro bono lawyer to do it for free is going to be much cheaper because there is relatively lower cost for your executor going through probate. The creation of a trust may also affect your government benefits, similarly as mentioned for deeds. Although a trust may avoid probate, if all assets are not properly retitled to the living trust, then your executor may still have to go through the probate process. A revocable living trust does not avoid creditors or taxes because under Pennsylvania law, this type of trust may be subject to inheritance, estate, or income tax. So, if you heard great things about trusts, especially on social media, keep in mind that trust laws are different in other states. It could be a great idea in other places where probate is more burdensome or the tax laws are different. And if you want to know exactly what the cost would be for you, definitely consult with an estate planning attorney about your specific situation.
What if I add someone's name to my deed before I die, so that they'll already be an owner of my home at the time of my death? Won't they avoid both probate and inheritance taxes? The answer is maybe, but not always. And adding someone to your deed can lead to unexpected financial and legal consequences. So it's usually not a good idea to use a deed to pass on ownership to your home. Before you make any changes to your deed, it's best to talk to an attorney. Adding someone's name to your deed can create a tangled title as well. As we previously discussed, if your name is still on the deed when you pass away, depending on how that deed is written, your share of your home can still be split amongst your heirs. Another important thing to note is that you will be giving the person you add to your deed immediate ownership of your home. That is, equal rights to your home. That means that they would have the same rights and ability to sell, transfer, rent out, or do various other things to your home without needing your permission to do it. This can all happen during your lifetime. Your eligibility for tax relief programs, public assistance, home repair programs, and other elder benefits can also be affected by adding someone to your deed. As previously mentioned, it is best to speak with an attorney before making any changes to your home's deed to weigh the costs and benefits of doing so, allowing you to make the most informed decision possible. Another thing you should consider while estate planning is to make sure that your home's deed is actually in your name. Sometimes people live in their home for their entire life, not realizing that their home's deed is not in their name. If your name is not on the deed to your home, you may not qualify for property tax assistance or home repair programs as previously mentioned. It is best to find this out before you're in need of these types of programs. Also, if your name is not on the deed, you may not be able to sell your home, rent it out, borrow equity from it, or generally do any of the things that legal owners can do. If you're not sure whether your home's deed is in your name, check out our deed handout linked below this video for a step-by-step guide on how to find your deed on the city's website and resources to speak with an attorney directly.
We want to emphasize 3 key takeaways from this presentation. First, creating a will is usually the least expensive and safest way to pass down your home. Creating a will is a super important tool to keep the government's hands off your house. Second, we gave you a lot of information today, but you should still consult with an attorney about how all this might apply to your individual situation. We'll provide some resources for free and low-cost legal services at the end of this presentation. Third, making a will is not a replacement for having tough conversations with your family members about your wishes.
Before we wrap up, we want to quickly mention 2 other documents that many attorneys will prepare at the same time as they do your will: a financial power of attorney and a healthcare power of attorney, also known as a living will or advanced healthcare directive. All 3 of these documents are standard parts of most estate planning legal services. A financial power of attorney lets you appoint someone that you trust to manage your money and property in your place if you should become unable to do so for any reason, such as if you are sick, injured, or need help as you age. It only stays in effect while you are alive. Don't give it to your chosen person right away. Just store it safely and inform your person where to find it. Once it's signed, that person can access your accounts, sell property, and make financial decisions on your behalf, so it's vital to choose someone trustworthy. Never sign a financial power of attorney without consulting a lawyer first. Make sure that you understand exactly the scope of the power that you're giving to the other person. A healthcare power of attorney, also known as a living will or advance medical directive, is another legal document that takes effect while you are alive. However, unlike with the financial power of attorney, your healthcare power of attorney should be given to the person that you've chosen to make medical decisions for you. This way, they will have it easily available as soon as it's needed. This document gives you an opportunity to express your preferences for medical treatment in the event that you are unable to communicate or are terminally ill, seriously injured, or unconscious. These can be very difficult decisions to make, but doing so ahead of time will provide clarity and peace of mind for you and your loved ones. You should discuss your expressed wishes with your healthcare agent to make sure that they fully understand your preferences.
So, where do you find help in Philadelphia? There are a number of free legal services in Philadelphia that will help you through the estate planning process. Here are some of them. For example, Senior Law Center provides for residents all throughout the ages of 60 and up who are in the state of Pennsylvania. You will also want to check with CLS, Community Legal Services, to see if you qualify, since they do have a low-income qualifications that you may or may not be eligible, but please call to see if you are a match for them. Next, we want to mention the Drexel Klein School of Law Estate Planning Clinic and the Stern Community Lawyering Clinic. These clinics run through Drexel University, are closed for the summer, but may be able to take new clients between August through April.